Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, be sure to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section of the video below. So we received an interesting inquiry here on our YouTube channel. This has to do with somebody who refused to do the alcohol test on the street. Criminal attorney, Fairfield. DUI attorney, Fairfield. Drunk driving attorney, Fairfield. Attorney, Fairfield. Let's see here. One day I was arrested for going quickly from one lane to another without turning my signal on. The police stopped me and I didn't want to do the breath test because I had drank 2 beers and already had a DUI from 2015. I was arrested and now I have another DUI. First, let's talk about that other DUI that you had back in 2015. Generally speaking, here in the state of California, people get 3 years of probation for a DUI unless it was a 4th offense or if they hurt somebody, in which case you could get up to 5 years of probation, and for obviously 4th DUI or hurting somebody, you could get up to 3 years state prison. That's a separate thing. But assuming that you're not on probation for a previous DUI, if you're no longer on probation, you do have the right to refuse the chemical test. You do have the right to refuse the chemical test prior to arrest. You do not have the right to refuse, however, after arrest. Once you've been arrested, and they tell you have to blow in the alcohol 4 device or take blood, if you refuse, they have to read something to you called the Trombetta advisement that basically tells you, hey, look, once you've been arrested, you no longer have the right to refuse. If you refuse, this will result in an automatic DUI and a far longer suspension of your driver's license. That for a second offense would be a 2-year suspension without the ability to obtain a restricted license. So if you did refuse at the station, that's going to be horrible because you're going to get a 2-year pull on the license, and the DA will just, you'll just get a refusal on your record. And essentially what that means is the DA essentially doesn't even have to prove the case, because if they couldn't successfully get the blood or breath out of you, well, you can't use your refusal as a basis for saying, oh, well, you guys don't have the evidence. Well, yeah, they don't have the evidence because you refused to give it up. They have the right to collect the evidence. So in that situation, you needed to have given it at least after the arrest, and since you didn't, you might just get a refusal, which will essentially be an automatic second DUI. You're kind of sort of screwed when you refuse. That's why, before the arrest, you can refuse. That way they can't compare the 2 samples. But after the arrest, you don't have the right to refuse. Please do not do that, because that's an automatic DUI. The first DUI really shouldn't affect you that much, although because it is less than 10 years old, you're still going to get additional punishment here. For instance, the worst thing here is that you're going to have to do the DUI school for 18 months. That's going to be the worst part of it. But since you were not on probation for the previous offense, you're not going to be looking at another 6 months county jail. Had you been on probation, then you would definitely be looking at an additional 6 months in county jail just by virtue of getting this new DUI. This isn't really that bad, but remember, in the future, never refuse the alcohol test, blood test after the arrest. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and ask your questions in the comments section. But if you've been accused of a crime and need representation in court, call us now, 1-800-862-7677. Criminal attorney, Fairfield. DUI attorney, Fairfield. Arrested for DUI, Fairfield. Attorney, Fairfield.